Hi, everyone. Thanks so much for joining us tonight for our next installment of our Ask Me educational webinar series. My name is Audra Hines, Vice President of Care Services for the Golden West chapter of the ALS Association. I want to start by thanking our generous sponsors, Mitsubishi Tanabe Pharma America, Cytokinetics, CNS, the Ron Malone Care Services Fund, as well as the Morris Family Caregiver Initiative for their strong support of programs like this one tonight. We couldn't make these happen without you, and we're so grateful for your tireless support of our efforts. We're pleased to be with you tonight to discuss a topic that's relevant to everyone living with ALS. The financial impact of this disease on an individual and a family can be devastating and life-changing. The latest estimate is that the costs related to the disease can be upward of $200,000 a year for medical treatment, home care, and necessary equipment for speech, mobility, and transportation. Many of these costs are not covered by insurance. As some of you know all too well, families are often left in turmoil as they're hit with astounding costs in managing this disease. The Golden West chapter serves to assist with managing these types of issues, whether it's helping to navigate insurance benefits, loaning out or helping with the purchase of a necessary piece of medical equipment or speech device, or offering a brief respite break for a spouse or caregiver. The chapter has programs in place to assist with specific needs. Please contact your care manager for more details on how we can help. And in an effort to have your financial planning questions answered tonight, I'm so pleased to introduce Sean Burr with VS Associates. Sean is a financial advisor and registered representative with VS Associates and comes to us with several years of experience in helping individuals plan for the future. He holds licenses in long-term care, life, and health insurances. Sean says, one of the most rewarding parts of his career is helping people reach and maintain their financial goals. And he also enjoys hosting events like this and feels it's an important way for him to help reach more people with valuable information. Sean, thanks so much for being here, and I will let you take it away.
All right, thank you, Audra, for that introduction. As Audra alluded to, my name is Sean Burr. I am an advisor with VS Associates. VS Associates has been in the San Fernando Valley since 1991, and we've been helping folks focus and maintain their financial goals, as well as planning for the future. So I'm going to share today with you some advice that I can give regarding estate conservation and how we can protect the ones that we love. So I thank you for the opportunity to come and speak today, although not necessarily in front of you. We're here on the screen, and that's kind of normal life for us nowadays. But I understand that nearly 5,000 people are diagnosed with ALS on an annual basis here in the United States. My coworker Shelly, her mother was diagnosed with ALS, and Shelly was her primary caregiver until she unfortunately passed in 2015. Shelly's 19-year-old daughter made a small investment with our firm this year, and she named the ALS Golden West chapter as beneficiary of that account, and that's really what got us started with the ALS Golden West chapter, and also trying to get as much information out as we can. So I'm going to go ahead and bring on this presentation. I'm going to take away my camera so you can focus on the information that's being stated. I know that we will have some time for Q&A a little bit later. So if you have some questions, please write them down, and I'm more than happy to get into that with you moving forward. So let's go ahead and jump right in. So again, thank you for joining us. We're going to go, like I alluded to, VS Associates. We're here in West Hills. So we've been here since 1991. We are a full service financial planning firm, as well as full tax preparation firm as well. So we really have a good grip on exactly what folks need and what you should be looking for as far as any financial plan moving forward. We do work with estate attorneys to even more entrust our assets to make sure that they are taken care of when we're no longer here. So let's go ahead and talk today about estate conservation and preserving wealth for your heirs. So our commitment is to provide some sound financial information, maybe help you identify some individual goals today. And also we're here to help moving forward in any way that you or anybody else that you know may be dealing with this needs. So what is estate conservation and why is it important? So 2 goals for your estate. One is to manage assets during your lifetime, which that is what we are primarily here to help. And the second goal of conserving your estate is to distribute assets upon your death. Let's take a couple estate lessons from the rich and the famous. Aretha Franklin, Queen of Soul, died in 2018 at age 76, leaving behind a score of wonderful music, but not a formal will. Some handwritten wills were discovered a little bit later in 2019. However, they were not taken care of in the right manner. Her sons filed documents in the Oakland County, Michigan probate court, listing themselves as interested parties and nominated her niece to be the personal representative. Her niece retired in 2020 from that role, and a Detroit lawyer was appointed interim estate manager. Ms. Franklin's estate will now be distributed according to the laws of Michigan, her state of residence upon death, because she did not have a formal plan in place. Of course, we've all heard of the drama associated with Michael Jackson's untimely death at age 50 in 2009. The King of Pop did have an estate plan, a last will and testament, and a revocable trust. However, he had not transferred all of his assets into his trust, and ongoing litigation issues, problems between family members continued well into 2013, 4 years after his death. He is still the estate is still locked up in probate court with the IRS challenging the executor's value of the estate. Today, we're going to talk about 4 principles of estate conservation, fundamentals, challenges that are associated with setting up and maintaining an estate conservation plan, some basic distribution techniques, and then later, what I'm really going to focus on today is some trust strategies, how we can make sure that our heirs and maybe a outfit like the ALS Association Golden List chapter can benefit from everything that we have accomplished during our lifetimes. So first of all, what is an estate? The estate is simply all the wealth that you have accumulated during your lifetime. This includes real estate, stocks, bonds, business interests, retirement plans, life insurance, personal effects, really anything else that you own. Benefits of some estate conservation. We are able to select who will receive the assets once we are no longer here. It can help you determine the distribution of your estate, which means you decide if, how, and when your beneficiaries will receive their inheritance. It will enable you to choose individuals who will manage your estate after your passing, including an executor, a trustee, and others. It can help you reduce estate settlement costs, including probate, expense, and taxes. If your children are young, it enables you to choose guardians for them. Finally, effective estate conservation can help provide liquid capital to cover burial, settlement, income tax costs, and long-term care. Couple challenges. We're going to go ahead and focus on some challenges that we may encounter as we develop our estate conservation strategy. And most people are going to face 4 main estate conservation challenges: finding the right attorney, dealing with probate, worrying about taxes, and again, long-term care comes up as a main point. First and foremost, any estate plan, long-term plan, any trusts or wills that need to be drawn up and handled properly, we're going to want to find a qualified attorney. The fact is that an attorney should be an essential part of your estate conservation team, and finding the appropriate legal professional to handle your estate can be a tremendous difference for you and your family. Any successful estate planning effort will result in several professionals working together. A qualified attorney is a crucial member of this team. You also want an attorney who is willing to work with other professionals, such as financial advisors and tax professionals. Finding the right attorney might involve a little bit of research. You might ask for referrals from friends or financial professionals. We all the time are giving out referrals to attorneys that we have worked with in the past and that we know take care of their clients. You can also contact the local bar association and ask for names of attorneys. The probate or trust committees is usually a helpful place to start. I do want to talk to a little bit about probate, and something that we should all strive to avoid. Sometimes it's unavoidable, but we definitely want to make sure we are making the greatest effort to avoid it. Probate is the court proceedings that conclude all legal and financial matters of the deceased and through which estate assets are distributed. The probate court acts as a neutral forum in which to settle any disputes that may arise over the filing and settling of the estate. From personal experience, I can tell you that probate can be extremely costly, both with time and with resources, two things that we do not want to waste, especially when dealing with losing a loved one. Some facts about probate. Unfortunately, it is very complex and has very serious drawbacks. Probate can be very expensive, and the cost can vary depending on state. State costs generally are only going to be a few $100s for the state court. What's really going to cost a lot is the attorneys that it takes to handle probate. Second, it can take time. We're still dealing with probate cases to this day that got started in 2018 because some of our clients came to us prior to setting up a financial plan. And the third thing is probate offers no privacy. Anytime we go through probate, everything becomes public knowledge of the court. And that means that anybody can see exactly what was in an estate and how it was distributed. Estate taxes is something that is very serious, and we want to make sure that we are focused on. Estate taxes are levied by the federal government and some other states on property that passes from the dead to the living. All of your assets, whatever the form of ownership, are subject to a federal estate tax and possibly state or inheritance tax as well. Even if the state doesn't affect your estate, the step up in basis or inherited assets is an important consideration that might affect your gifting strategies. We'll get into that a little bit more as we move on. Some recent changes to the federal estate tax law. Back in 2012, it made the 2010 Tax Relief Act permanent, resulting in a $5 million federal estate tax exclusion. It made that permanent. Portability of exclusion between spouses. That just means the transferability between one spouse to another of that used to be $5 million in 2017. The Tax Cuts and Jobs Act nearly doubled it, actually more than doubled it. The federal estate exclusion to 1.18 million. That does have a provision in it which keeps pace with inflation. So in 2021, the exclusion ratio per person is now 11.7 million. But after 2025, it's scheduled to revert back to its pre-2018 level, back to about 5 million. So how do our federal estate taxes work? It's quite simple. We take the net value of the estate. Now remember, the estate is everything that you have amassed over your entire life. That is your assets, your retirement assets, your home, any of the valuables that you have as far as jewelry or coins as well, are the net value of your estate. Subtract out any state tax exclusion, which is is over 11 million per person. So per married couple, it's over 22 million. Whatever's left over of that is multiplied by the estate tax rate, which right now is 40%. Those are the federal estate taxes too. Doesn't take a lot to see that estate taxes can really cut any type of inheritance that you want to leave to your heirs, or also leave to a charitable organization as well. There is an annual lifetime gift tax exclusion. We each have one per person. You're able to give $15,000. That's per person. So the married couple are able to give $30,000 per year. Lifetime is 11.7 million. There is a caveat there. If you are donating to a 529 plan, which goes for education, higher education for a minor, for a child. They actually are able to accelerate this $15,000 annual limit 5 years, and we were able to levy $75,000 worth of our assets to a 529 plan for a child later on in life for college education. There is an unlimited marital deduction, meaning between spouses, the transfer of wealth is unlimited and exempt from any federal, state, and gift taxes. I did want to touch on the difference between a step up in cost basis as well as a carryover basis rule. As a general rule of thumb, if you hold an appreciated asset, such as a house, say you bought a house 20 years ago for $100,000, and today it's worth $500,000. Definitely not in the valley, but somewhere maybe outside of the valley. It's worth $500,000 today. If you were to sell that house, we have to pay taxes on that $400,000 of gain that we would have appreciated. Once you pass away and pass that real estate asset on to your children, they get what's called a step up in cost basis. So they get the value of the home, in this example, based on the date of death. So they would assume that $500,000 cost basis. If they sold the property for $500,000, there's no capital gains tax to be paid. Step up in cost basis rules don't apply, however, to gifts, which are subject to a carryover basis. In that same example, if you were to gift that $500,000 house to your children, they would assume your $100,000 cost basis. Meaning if they were to turn around and sell that house for $500,000, they would owe taxes on that $400,000. So some tips to think about when focusing on the transfer of wealth through real estate. And I really wanted to touch on this as well because the potential need for long-term care is growing and rates are rising by the minute. So long-term care is going to be one of the most expensive individual asset depleting sources in our retirement and even before. So what would happen to our estate if we needed long-term care? Most people don't think of long-term care as an estate conservation issue, but it could become one if your estate is depleted as a result of expensive long-term care costs. I'll be happy to answer any long-term care questions here at the end as well. Okay, so we covered the fundamentals and some challenges that we often run into when we're dealing with estate conservation. I want to talk about a few distribution techniques, some basic ones. Individually, I would love to get into some more in-depth distribution techniques, but we'll cover a few here today. The 4 distribution techniques that I want to talk about are intestacy, wills, living trust, jointly held property, and contracts. So intestacy basically means do nothing, let the chips fall as they may. There's a couple issues that we have with that. 4 main problems. First, the courts won't have anything to work with in determining your desires. So what you had planned on will not be taken care of. Second, you have done nothing to help eliminate the fees and taxes brought on by the act of death. In some cases, your estate may be subject to federal and state effects and estate taxes. Third, your estate may go through a long, expensive probate process. We've already detailed the problems there. Finally, if you haven't named a guardian for your minor age children or legal dependents, the court will determine guardianship without your input. Second technique you can use to distribute your assets from your estate is a will. A will is a list of instructions that tells a judge exactly how you would like your estate to be distributed. If the probate court upholds your will, the court will use it in its deciding how to distribute your property to your heirs. In your will, you can also appoint a guardian for your minor children or their legal dependents, and you can elect an executor or personal representative for your estate. Some problems that we run into there is we're still dealing with probate and the cost and time associated with probate. Also, we haven't done a lot to eliminate taxes and costs. Jointly held property is another way to distribute your assets upon death. In many people's minds, property ownership is closely related to a will. Many of us have been told that there are ways to use property ownership to avoid probate, and in some cases that may be true, but we need to make sure that we have a focused plan in order. Perhaps the most widely used form of ownership today among the individuals is joint tenancy. Most married couples use joint tenancy. There is no percentage of ownership that is distinguishable. Both entities own that property jointly. A second type of property ownership, tenancy by the entirety. This type of co-ownership must be between married couples. Though similar to joint tenancy, tenancy by the entirety treats an estate as a unit, which means that neither spouse can sell an asset without the other's consent. Its main feature that each spouse has a right of survivorship. Tenancy by the entirety is not available in all states. Third type, tenancy in common. Two or more people, up to any number, may own property as tenants in common. Each tenant owns an undivided interest. This means that each owns a specified percentage of the whole, often based on his or her contribution to the purchased property. So some dangers that we run into there, because the survivorship features associated with joint tenancy, there are dangers in holding property in joint tenancy with other individuals. Occasionally, there are instances in which one spouse has died and the surviving spouse takes title to the residence or the piece of real estate with their children as joint tenants. Remember, if you change the title of your property by adding another co-owner or co-owners, it creates a present gift. From that gift, there could be potential tax liability. Some contracts that can help you distribute your estate. Life insurance. Life insurance has been used for hundreds of years, and it is a way to protect your family, your loved ones, in case you are no longer here and able to provide for them. Pensions, annuities, retirement plans, all of these can have beneficiaries added to them that directly transfers that particular asset to another individual or establishment. And this is an important slide. I want to, if you take away one thing from today's presentation, I want you to realize the importance of beneficiary designations. So beneficiary designations supersede anything that you put in a will. They supersede anything that you put into a trust. They avoid probate. And they are written into law as soon as you pass the law. As soon as you pass away, that becomes a binding document, and whatever beneficiary you have listed on your IRA, your 401k, your annuity, your life insurance plan, that must be carried out by the insurance company or whatever custodian you hold that plan. All right, now fourth and most important today, I want to talk about some trust strategies that will help us utilize assets while we're living, but also potentially give back to societies like the ALS Golden West chapter. Because they help us, we would like to help them as well, maybe when we're not around. So what is a trust? The classic definition states that a trust is a legal arrangement under which one person or institution controls property given by another person for the benefit of that third party. Most people think that trusts are only for the rich, but that's not necessarily so. If properly structured, certain types of trusts can be used to help shield assets from estate tax liability. Some trusts can completely avoid probate, and because trusts offer some unique advantages over the estate planning methods, they may be the answer to many of your estate conservation needs. Several parties can be involved into a trust. We have the grantor, that is the individual that is giving the assets into the trust. We have the trustee, that is the person that is managing the trust. And we have the beneficiaries. The beneficiary can be the person or entity that the trust is there to protect and help once the grantor trustee has passed. Oftentimes, we see the grantor, the trustee, and the beneficiary all be the same person or spouses. A couple different types of trust: testamentary trust and living trust. The testamentary trust is established by a will. It helps you Controlled distribution can help you reduce fees and taxes. Unfortunately, it does not avoid probate. A living trust helps control distribution, same as a testamentary trust, can help manage fees and taxes, but it also avoids probate if it's structured properly. And that's the main goal of any type of transfer of wealth, is to avoid probate and mitigate taxes and fees. Two different types of living trust is revocable and irrevocable. A revocable trust can be dissolved or amended at any time while the grantor is still alive. Once that grantor passes along, it becomes an irrevocable trust, which cannot be changed or modified once that individual has passed on. I wanted to touch today on special need and incentive trusts as well. A special needs trust may be established as a standalone trust or incorporated into a revocable living trust. It is also important to reference the trust in your will if you have one. A properly executed trust can help provide for an individual's lifetime care and other financial needs while maintaining eligibility for government programs such as Medicaid, Medicare, Social Security, disability insurance. When someone with special needs receives a life insurance payout or inherits directly, he or she could be disqualified from government assistance programs, and a special needs trust avoids such an outcome. Some people prefer to leave an inheritance that enhances family members' quality of life without enabling beneficiaries to become unproductive or financially irresponsible adults. Provisions in an incentive trust outline requirements or milestones that must be met before a portion of the trust's money is awarded. Provisions may be drafted to promote education, entrepreneurship, public service, or philanthropy, to supplement earned income, and even to discourage certain harmful behaviors. A couple advanced trust strategies that I'll get a little bit more into right now. An AB, often called a marital and bypass trust, which could kind of become a thing of the past due to the increasing federal exemption level, which is now over 11 million per person. A revocable life insurance trust and some charitable trusts as well. So when folks want to consider an AB trust, the purpose of a marital and bypass trust combination is to enable both spouses to use the estate tax applicable exclusion upon their deaths, which shelters more assets from federal tax. This was really popular prior to 2011 when the exclusion ratio rate on the estate went up to 5 million, and then again in 2017 when it went up to 11 million. Now with most states and federally portability transfer between husband and or between spouses, AB trusts we're really not seeing as much anymore. A different type of trust is an irrevocable life insurance trust. Many families use life insurance proceeds to help cover estate taxes, probate fees, and administrative costs. Life insurance policies can offer liquidity, income tax-free death benefits, flexibility, and tax-deferred cash value growth. But if you own a policy, or it is payable to your estate, the proceeds of your policy will be subject to estate tax. So using an irrevocable life insurance trust, ILIT for short, helps eliminate estate taxes, keeps policy proceeds out of the estate, and provides ready cash to help pay the cost of insurance, administration, and estate taxes on the estate assets that exceed the applicable exclusion amounts. So the way that this works is the trust pays for a life insurance policy of the insured. Once the insured passes, the life insurance policy proceeds go tax-free to their heirs, while the remaining assets in the trust can be passed along and used for settlement of their estate. I did want to talk about charitable and wealth replacement trusts as well. There's a few different here. Charitable remainder trust, charitable remainder annuity trust, charitable remainder unit trust, charitable lead trust, and a wealth replacement trust. We get a little bit into each of those right now. So a charitable remainder trust, the donor will be donating their property into the trust. However, the donor might still need to utilize that property or asset for ongoing income. So the trust, which now owns the property or the assets, will still be generating income back to the donor. Of course, once assets are gifted to the trust, it's possible for the trustee of the trust to sell highly appreciated assets or income producing assets, incur no current capital gains tax, and reinvest those proceeds. This is irrevocable. So once the donation has occurred into the trust, there is no going back. However, the donor can utilize the assets of the trust for the remainder of their life. Once they pass along and their spouse or heir, the trust then donates the property or assets to a charitable organization like the ALS Foundation. So charitable trust remainder considerations. They can provide regular income for a set term throughout your lifetime or for the lives of both you and your spouse, depending on how the trust is structured. It can also be fixed with a charitable remainder annuity trust or variable with a charitable remainder unit trust. So the trust itself can pay out either a set amount on a monthly or annual basis, or it can pay out a percentage of the assets on an ongoing basis. So as the assets continue to appreciate, the income that can come out of the charitable remainder trust can also appreciate. Charitable lead trust is a little bit different. In this example, the donor is still donating the trust. We are transferring the property into the trust, but in this example, the charitable organization receives the income that is generated from the trust. Once that person, the donor, passes along, the assets, the property in the trust, or any of the other assets, get passed along to the beneficiaries. So this is a way that you can, this is for folks that have some assets that are appreciated, that maybe don't need the income that's being generated by these assets, but they eventually want their house to go to their beneficiaries. So this is a way that they can donate all of the income that's being generated from that property or those assets, but still make sure that their heirs are taken care of once they are gone. So some considerations with the charitable lead trust. The assets eventually get returned to the beneficiaries, helps reduce or eliminate completely gift or estate taxes. It does provide a current gift to charity, some donation, some tax favorable treatment there as well. The donor losses present in an interest property during the lifetime of the trust. You still may owe some taxes on the income, but if it is handled properly, you can get those write-offs as well. So the donation, again, is irrevocable. So once the decision is made, that must continue. One other one that I wanted to get into today, before we go ahead and wrap this up, is the wealth replacement trust. So this is kind of a combination of two of the different trusts. The donor puts the property or the assets into a charitable remainder trust. They're able to still use that income for themselves and also to fund a wealth replacement trust. And usually in that wealth replacement trust, we'll have a life insurance policy that's being paid by the property that's been donated upon the death of the donor and or both the donor and their spouse. The life insurance benefit gets paid to the beneficiaries, tax-free, and the property or assets that were in the charitable remainder trust then get donated to the charitable organization. So what trust might be appropriate for you if we want to leave a legacy, take care of our heirs, but also donate to a charity that has helped us and our family out? A charitable remainder trust removes the assets from our estate, possible income deduction, income tax deduction because of the donation, and then also reduction in estate tax liability because the assets are no longer a part of the estate. Charitable lead trust will be beneficial if we don't need any income from the assets, but we want to retain ownership of those assets and our heirs eventually, but we want to donate an ongoing income or annually or monthly to our favorite charitable organizations. And then a wealth replacement trust, if we still need income, but we definitely want to leave a legacy behind to our heirs in form of cash, but we also want our assets and or property to be donated to the charitable organization eventually. As any financial plan in life, your estate plan should be reviewed periodically. Tax laws are constantly changing. The composition of your holdings and the value of your estate may change on a monthly basis, annual basis. If you were along for the ride in the stock market last year, it could be on a daily basis. And your family situation can change. The birth of a child, birth of a grandchild, divorce, marriage, any of these life changes can affect your estate plan, as should be reviewed periodically. So I hope that you got a lot of knowledge from me today. I definitely will be here for the Q&A in a few minutes here. But what can you do from here, right? We want to put our knowledge to work. You can do it yourself. You can try and do it alone. What we do not recommend, you can work with professionals like us. You can work with professionals maybe that you worked with in the past, but we definitely want to have a team, an estate planning team set in place to make sure that everything is taken care of. And it's one less thing to worry about when we're dealing with everything else that we're dealing with in life. And the third, procrastinate, don't do nothing, don't do anything. Intestacy is kind of what we discussed earlier. That is something that I absolutely do not recommend, and I hope you don't do that. So right there, I'm going to go ahead and open it up, and I think we're going to bring Audra back.
I'm here. Yeah, thanks so much. Yeah, Sean, if you want to stop sharing your screen, that's totally great.
I'm going to do that right now.
Perfect. Thank you. Oh my gosh, this was a ton of information and so helpful and so relevant to so many of the people on this call, Sean. Thank you so much.
No problem. And I do know that I threw a ton of information. I tried to cram as much in as I could in that 30 minutes. And I think I went a little bit long. Anybody after this call, please feel free to give out my information. I'd be more than happy to get into some more detail. This was a 10,000 foot view.
Yeah.
Everybody has a different situation, and I would love to get into it individually.
Okay, wonderful. Yeah, actually, that was a question someone asked if the presentation would be available, if we're able to share that with the people who were on this call tonight. Is that doable?
Yes, absolutely. I just need to get approval from my broker dealer to send it out. So yeah, please, either you can work with me. I can get a list.
Yeah,
to send it
you
out
can send it to me.
Or once I get it approved, I can get it forwarded over to you as well.
Okay. Yeah, you can send it straight to me. That's awesome.
Okay.
Yeah, I do have a few questions here. I'm just going to ask them out loud and we'll go from there. One question is, what's the most economical way to create a trust?
The most economical way. So there's a lot of online places that are available now. LegalZoom is one of them that are a little bit more cost effective. Really depending on how in-depth your situation is, depends on exactly what you can use. So probably a quick conversation with me, or if you do have a financial advisor of your own, will probably give you a good idea of exactly what you need. I generally say that working with an estate attorney is always going to be the best route. It's not the most cost effective, but it is going to be the most beneficial, because that is the way that you can get your exact needs, wants, and wishes taken care of.
Wonderful, thank you. Which retirement assets are better to use for paying for care, and which are better to save?
Well, I always say tax-free is the best to save. So that's going to be your Roth IRAs and a couple other slight accounts that you might have. It really depends on your tax situation. So generally speaking, if you're paying for care, a lot of what you're paying out can be written off as a deduction. So if that is the case and you're able to utilize IRA or 401k assets that are going to be taxable to you, but if we're able to offset that tax that's owed by credits or deductions that you get from paying for that care, generally that's going to be the best way to go. But again, I always say you save the tax-free for last.
Okay, great. And what's the best way to prevent your heirs from disputing the trust?
By having a trust. Once the trust is established, and you have a pedigree of beneficiaries and a successor trustee, there is no disputing it. And whoever the trustee is, it's unfortunate because we see it quite often. Kids don't agree with what their parents' decisions are, and there's first marriage kids that don't agree with what's going on. So we see it all the time. But that is why we say to work with a state attorney, because once that trust document is irrevocable, either upon your death, any revocable trust will become irrevocable. There is no going back and changing it. And the trustee, generally speaking, has the assets, because what's the worst that can happen is they bring a lawsuit, they tie it up in litigation. So the trustee of the trust, whoever you appoint to handle your assets and your estate, has the backing of the trust to be able to fight that. So if it does come to legal action, they will have the assets of the trust to help protect what you want.
Okay, got it. That's helpful. Thank you. If you're in the process of applying for Medi-Cal, trying to become eligible for Medi-Cal benefits so that you have, home care through the Medi-Cal program, the question is around which retirement accounts count against Medi-Cal eligibility, right? So in terms of assets, and which do not, if there are any that don't.
So that's kind of when I went to when I discussed the special needs trust, because again, generally speaking, and I hate to do generally speaking, but there's so many ifs. So again, love to talk to anybody on a one-to-one basis.
Right.
But generally speaking, all of your assets are going to count against Medi-Cal. So that's your IRAs, your non-IRAs, any assets that are in your individual name. So a way that we avoid that is with a special needs trust. The special needs trust can own all of the assets, and the individual doesn't own any. But the special needs trust is designed to assist the beneficiary with his or her needs. So the best way to go about that is through a special needs trust. We completely get rid of everything in our estate, and then that allows for the Medi-Cal parameters to be met.
Okay, great. Little bit different. If a brokerage account is titled payable on death, would it avoid probate?
Yes. So TOD is generally what we call that, a transfer on death. So any of your IRA assets, your qualified assets, your pension, your 401k, your IRA, generally speaking, those have to have a beneficiary set up. But your non-qualified assets, a brokerage account, don't have to have a beneficiary. But you absolutely can add a transfer on death beneficiary to that account, and that avoids probate, and it's free.
Okay. Great, great to know.
Again, one thing that I leave with you today is to make sure your beneficiaries are in order. It avoids probate, and it's free.
Great, that's great advice. I have a question here with a disease like ALS and the option to make a choice around right to die legally in California. If a person with a diagnosis like ALS makes this choice, can their heirs still collect their life insurance?
That is actually a new one for me. I would have
Okay.
to do some digging on that. I would hate to give out any incorrect information, but you are able to, obviously with things that we have today, healthcare directive, durable healthcare directive, I'm sure you guys are familiar with, that allows you to really dictate exactly the end of your life. So it can definitely be set up, but I would have to find out some more information on that. That's a new one for me.
Okay, sure. We got a question from someone when they registered for tonight's webinar who says, I have a small house that's not wheelchair accessible in an irrevocable special needs trust. I need to buy an accessible house, but I can't find any place that will allow loans for property in irrevocable trust since they can't sue against it. Any advice?
So as far as I understand that, the title, the deed of the house is in the irrevocable trust, and now there can't be any changes to that. It sounds to me like if you were able to liquidate that house, which I know it would be difficult if it is an irrevocable trust and that wasn't how it was stated before. Hopefully that those assets would give you enough to leverage what you have to buy a new home. But that's again one of the caveats of irrevocable trust is we want to make sure that everything is how we want it, but changes do occur. So I would consult an attorney, an estate attorney that might be able to help you out with that one.
Okay.
That one's a little above my pay grade.
It's very detailed, that's for sure. This is the last of the questions I have in here. I want to give everybody just another couple of seconds. If you have another question for Sean, please put it in the Q&A function at the bottom of your screen. Otherwise, Sean, this has been such a pleasure, and so much great information, such good education for everybody on the call today, including me. I learned a bunch of stuff too, so thank you so much. I'll look forward to having the presentation from you later. And I just want to really wrap up tonight, and we're so grateful to each of you for your time and commitment and for being a part of our community. Thanks so much again to our lead sponsor, Mitsubishi Tanabe Pharma America. I want to let you know we have some fun and inspiring events coming up in September and October. For those of you who are endurance enthusiasts, or if you just fancy a family bike ride, please join us for the virtual Napa Valley Ride to Defeat ALS on Saturday, September 18th. And also join us for the next installment of this Ask Me series on Thursday, September 30th, that will focus on alternative therapies and ALS. The Walk to Defeat ALS is on October 23rd, and it's the #1 way for us to unite as a community to fundraise and build awareness for those living with ALS. Whether you plan to walk, hike, bike, roll, swim, or just picnic with your family, please join us in honor, in memory, or in support. You can find all the details at walktober.org. In addition to the information provided tonight, the Golden West chapter offers free resources that you can find online at alsgiftplanning.org, including a free estate planning guide. As you know, philanthropy fuels everything we do, and some people choose to support the chapter's programs through an estate gift. If you wish to learn more about that, please reach out to Emily Stork, our Director of Development, and she'll be more than happy to speak with you. Also, please watch for the short survey on tonight's presentation you'll receive via email in order to help us plan for more future programs like this. Thanks so much again, and we'll see you next time.